Hello, and welcome to another edition of Coffee Talk with immigration attorney and estate planning attorney Brian D. Lerner. In this particular episode, I'd like to talk a bit about amending the trust when you can. What are the parameters for doing it? When you can't do it, and so forth. Now, what exactly does this mean? Well, let's say that you make a living trust. Okay, you go to the lawyer, you make a living trust, and then at some later point, something changes. Either you have another kid that wasn't put in there or specifically discussed. You might get divorced. You could get new property. You might have new bank accounts. You could have new investments. You might have sold property. You might have lost investments. You might have been given charitable contributions. You might have given charitable contributions, and so on. I mean, there's lots and lots of reasons why you would want to amend or change certain provisions of a living trust. So the question becomes, can you do it? Okay. Um, First, you have to know whether it's revocable or irrevocable. Um, it's really what that means. If it's revocable, it basically means it can be changed. It can be revoked, changed, edited, amended, so forth. If it's irrevocable, then it's set in stone. Okay, and you are unable to amend or do an amendment. So, for example, if you look at other estate videos that I've done, you know that, for example, a Q-tip uh, trust is when one of the spouse dies and then transfers, essentially creates a new sub trust that transfers a certain property into a Q-tip trust, and that new Q-tip trust is irrevocable, cannot be changed. And there's reasons for that. Once you're deceased, you can't say no. I don't want you to change that, or it's okay. I mean, you want to have guarantees that it is irrevocable. So what we're talking about here is only trusts that are revocable, and basically, if we're talking about a married couple, you and your spouse will have a revocable trust during your lifetimes, until one of you dies, and then even then, some of it's still revocable, and other parts of it are irrevocable. But that's the first thing you need to look at. Now, the bottom line is a trust is revocable unless it provides otherwise, and the providing otherwise is when it does create a irrevocable subtrust. Now, the power to revoke a trust includes the power to modify it. So revoking is just completely invalidating basically the entire trust. So amending it means to modify it, and if your lawyer, your estate planning attorney, properly prepares this, then there will be a provision in the revocable or the trust itself, which will say that it is permitted to make amendments and exactly how those amendments are to be made. So there's no question, whether, legally you don't have to actually have the amendments notarized, but maybe in the revocable trust, the provision will be that both of the trustees need to sign whenever there's amendment, and possibly it needs to be witnessed and or notarized. I mean, you can pretty much make it any way that you want to make it, in order to allow and make clear that it is properly done. So normally what you'll see in a typical revocable trust is a statement that says something to the effect that the settlers may at any time during their joint lifetimes alter, amend, revoke, or change the written instrument, which is signed by both settlers and personally delivered to any one of them, by certified mail and so forth. And then, it could go on and on to say whether consent is required or what happens if consent is not given, and so forth. So That basically is what an amendment is, how it is done. You need to make sure you get an estate planning attorney that can properly word anything regarding amendments, because you can imagine if one settler says later after perhaps one of the spouses dies, that, oh well, you say there was an amendment that allowed Joe to get the house, not Bob. And so, then of course the whole, they could go into probate and there could be family battles and all of that. So while amendments at first blush may seem to be, oh, you just make a couple changes to the trust, you need to make clear of what changes can be made, how it's notified, how it's consented to, and so forth, so that there is no ambiguities, and it can be easily defeated if someone wants to claim that there was an amendment, and may even have some signed papers done properly. So keep that in mind. If you like the video, uh, uh, click OK, click you like, and then go ahead and subscribe if you like. And you can call and or email my office, give you a free consultation on your estate planning, let you know what and how to go about it and what needs to be done. Okay, more in the coming videos.